my name is Laurie Bristow, the President of the College. I'm here to welcome you all this afternoon. But of course, I'm going to keep this very, very short because you have not come here to listen to me. So what we're doing this afternoon is starting the first seminar, the Cambridge seminar series on law and the climate crisis for this academic year. The series started last year with speakers from academia and practice, reflecting on how law affects and is affected by climate change and the climate crisis. Of course, the series reflects the college's long-standing interest profile on climate law, reflected in the fact, of course, that we host the Centre for Climate Engagement here in the college. So the second series, today's event is starting with some reflections by Lord Robert Carnwath. He hardly needs introducing, but my job is to introduce him. He's a former Supreme Court Justice of the UK. He holds, of course, many other positions, academic positions, including an honorary professor at University College London, visiting professor at Oxford, visiting professor at the LSE, and his connections with Cambridge include, but are not limited to, being the Yorke Distinguished Visiting Fellow in the University of Cambridge. He'll talk today about judges and climate change. That's the theme of today's discussion. And so to just very briefly summarise in one sentence what we're talking about here, I think as everybody recognises, as we see the growth in climate-related court cases, climate-related litigation, Lord Carnwath will explore the roles of the court and judges in tackling the climate crisis. So thank you very much for joining us on a Friday afternoon. Thank you very much, Carol and the team, for organising today's events. Above all, thank you, Lord Robert Carnwath. Over to you.
Well, thank you very much for that kind introduction, and thank you for coming. It's a great pleasure to be here. It's a lovely place, I must say. I remember as an undergraduate here many, many years ago watching the cricket on Fenners, which is a little further from Trinity where I was. But it's really very nice to see you. You notice I put on a tie, especially for the occasion, because I wasn't quite sure what the dress code includes all is, but I can see it's slightly more relaxed than that. But I'm going to keep my tie on. Now, I'm afraid I've given quite a lot of talks over the last few years about climate change and the law, and some of you may have seen some of them, and I make no apology for the fact that some bits of what I'm going to say may have popped up occasionally before. But today I'm really wanting to look at it from a slightly different perspective, which is to look at some of the sort of important climate change cases over the last few years, but to look at them from the sort of point of view of the judges. I mean, the question is really to what extent do or should the personal attitudes of particular judges to issues such as climate change affect their judgment in individual cases? To what extent should judges become quote activists, is a word which has been floated around quite a lot lately. Now, I start with a sort of experience of my own, slightly curious experience from some 10 years ago. In September 2015, ahead of the Paris COP21 later that year, I thought we ought to have to look at some extent at the way courts were dealing with climate change. And I helped to organise a conference with the Supreme Court under the title Adjudicating the Future, Climate Change and the Rule of Law. And we had the support, in fact, of the Foreign Office, and we had a very good gathering of judges of the world talking about their experiences. But during the background, my own background, I've been a judge for some 25 years, but my own experiences were general, but I'd always taken an interest in environmental law, and in particular, I had since 2004 been a member of a judicial task force set up by the United Nations Environment Programme following the Johannesburg Conference on the Environment, which was designed to try and improve understanding of environmental issues among judges around the world. And part of that process had been setting up, for example, the European Union Forum of Pledges to the Environment, which we set up in 2004, which brings together judges from all over Europe every year for a conference on environmental law themes. So I was quite involved in it, and I began to take a particular interest in climate change cases, although we didn't have many cases as such in the Supreme Court. And the background in this country was we had a cross-party consensus on climate changes since 2008, when we passed the very important Climate Change Act 2008, which provides, as you will know, a very strong framework for moving towards net zero in 2050. But we organised this conference, and one of the sessions was a public lecture given by Professor Philippe Sands, who you probably know, on climate change and international law. And that was hosted by me at the Supreme Court. And it could be seen online through our website. And he looked at the possible role of international law, and in particular the possibility that a small island state directly affected by rising sea levels might persuade the United Nations General Assembly to make a reference to the International Court of Justice on the obligations of states in respect of climate change. Now, at the time, that seemed quite a far-sighted idea, although now, of course, as you probably know, there's been earlier this year a decision of the International Court of Justice on just such a reference. So it was quite far-sighted of Philippe Sands, but certainly nothing particularly controversial, you might have thought. But I was surprised when, a week or two later, I was alerted by the Supreme Court press office to an article in The Spectator, written by one James Delingpole, under the headline, quotes, "A Supreme Court Justice and the Scary Plan to Outlaw Climate Change." The burden of the article was that I and my fellow judges were scheming to close down the debate forever using the, quote, sledgehammer instrument of the International Court of Justice, thus leading, he said, to an effective global ban on anyone talking about climate change. He bemoaned the fact that, quote, the Green establishment embracing everything from the Obama administration to the Vatican and the BBC was now being joined, it seemed, by certain members of our famously neutral and apolitical senior judiciary. I then discovered that an earlier article on the same theme by the same author had appeared in the American website called Breitbart. You may know about Breitbart since Donald Trump, in those days it wasn't so well known, but he did. That was Steve Bannon ran that, and he became a great Trump supporter. Anyway, that ended on the same theme, ended with the comment, "Sands is a dangerous man, even more so the man who instigated the conference, a hitherto obscure activist judge called Lord Carnwath." That apparently was me. Now, he gave me quite a lot of street cred with my environmental friend. But it was a totally absurd thought that somehow we were sort of trying to close down, but it showed in a way how different attitudes were in this country, where it was in those days completely non-political the attitudes across the Atlantic. I'll come back to that, but it just sort of raised the question of what activism actually meant. Now, as I said, I have been involved with environmental cases and environmental conferences. Apart from the European Forum, which I mentioned, we also more recently set up a thing called the Global Judges Institute on the Environment, led by a brilliant Brazilian judge called Antonio Benjamin. And funnily enough, we had a debate when we were doing the European Forum, we called the European Forum of Judges for the Environment. But when we were looking at this 10 years later, setting up the Global Institute, there was quite a debate about whether we should say for, without showing we were being too pro-environment. So in fact, we called it on the environment, or de l'environnement, as opposed to for. But I don't think any of us sort of thought that we were in any way prejudicing our judicial independence by taking an active interest in the environment and environmental affairs. But some jurisdictions have taken a more rigid approach, particularly a case in the Norwegian Supreme Court in 2020. That was a challenge to the government's decision to allow oil exploration on the Norwegian continental shelf under Article 112 of the Constitution. The challenge was under the article which confers the right to an environment that is conducive to health and imposes on the state authorities an obligation, quotes, to take measures of the implementation of these principles. So there you have a constitutional framework protecting the environment, obligation of the state to do something about it. But now one of the judges of the Supreme Court was and is a friend of mine called Ragnhild Nerf, who I've met at a number of these conferences around the world. And although, like the other judges of the court, he was a generalist, he has taken a special interest in environmental law. An objection was taken to her sitting on that case in the Supreme Court because she was thought to have perceived environmental sympathies. What she had done, and I mean the judgment, you can read it, the principal objection was that she was involved in something called the World Commission on Environmental Law, which is a very influential international non-governmental body which brings together environmental groups around the world. And that she was a member of their steering committee. And there were two particular pronouncements of that body which drew attention. The first came in a declaration adopted by the WCER, in which the judge had been, which he had been present, which had included a reference to the so-called in dubio pro natore principle. That is the principle that in cases of doubt, matters before the court should be resolved in a way most likely to favour the protection of the environment. The other was a project of the WCER website under the title Fighting Climate Change, a best practice guide for judges and courts. Now, to me, those things didn't seem particularly contentious, but they were said to be slightly pro-environment. And in the view of the majority of the court, these statements, even though not directly attributable to her, they were made by a group of which she was a member, and they went beyond acceptable limits in that they expressed what the results should be in court cases dealing with the environment and climate change, or, quotes, must at least be read as a wish that certain considerations are given particular weight. Now, I must say, I said this in public in an upper occasion, take with great respect, find that conclusion pretty odd. In the context of a constitutional clause which provides special protection for the environment and natural resources, it seems odd to exclude a judge of acknowledged environmental expertise merely because she may subscribe to the view that there should, where legally possible, be a presumption in favour of protecting nature and the environment, and further that where ministers fail in that task, it is the job of the courts to hold them to account. In any event, one of the strengths of a plenary court, that one sits, as I have done in a sort of Supreme Court with other judges, is that it brings together judges with different specializations and points of view and allows for constructive debate between them. So if anything, it averts exclusion of that expertise and that point of view might be thought likely to weaken rather than strengthen the perceived authority of the ultimate decision. Now, I'm not, of course, suggesting that the particular case her involvement would necessarily have led to a different position, but it could be said that the court took certainly not an active view, rather a passive view. They rejected the challenge, saying that, quotes, decisions in cases regarding fundamental environmental issues often involve political balancing and broader prioritization. Democratic considerations, therefore, support such decisions being taken by popularly elected bodies and not by the courts. And so Article 112, in spite of its apparently positive word, was to be read as, quote, a safety valve, allowing the courts to set aside a legislative decision only if the legislator had not addressed a particular environmental issue, or the duties under the article had been, quote, grossly disregarded, the threshold being, quotes, very high. So now that was obviously an independently taken decision. I'm not saying it would have been different if Ragnhild had been on the court, but it's certainly not an activist position. Where, I mean, we can contrast that with other cases around the world, perhaps notably the Indian and Pakistan courts, which have tended to favour a degree of activism which perhaps goes beyond anything we would have. One of the judges who came to our conference in 2015 was a judge from Pakistan called Mansour Ali Shah, who again has become quite a good friend. I met him at a number of people here may have met him. He's a very lively judge, and maybe terribly bright, and he was, before he became a judge, quite an active lawyer representing environmental groups. But no one sort of suggested that disqualified him from being a lawyer. And the case that came in front of him in 2015, shortly before our conference, was a case called Lake Hari against the Pakistan, and in the High Court of Lahore. And basically, the case was brought by a farmer who claimed that his land was being flooded because the government had simply not implemented its policies on climate change. And although they had fairly well developed policies, they had actually not done anything to bring them in to give them effect. And so he did what something went much further than we would ever regard. He actually first of all, he found in the Constitution says nothing about the environment. It does talk about the protection of life, but like drawing on other cases from India and Pakistan, he held that the right to life includes the right to a healthy environment, which includes climate change. And so the government had a duty under the Constitution to protect it and take measures to do so. Contrast that with the rather narrow view taken by the Norwegian court of their specific mention of the environment in the Constitution. And he, in order to sort of move things along, he established a commission of interested parties, including government representatives, to work out how to implement the policies and to develop a program and to report back to the court, and that indeed happened. And on the whole, I think it was regarded as very effective. So, and as he said to us at our conference, he said that the proceedings had not, in fact, been adversarial. There wasn't any appeal from him. I think the officials of the government were quite pleased to have someone to sort of force them to take action which they knew was necessary. And so it really moved things along. Sorry about this. And then much more recently, I don't know how many of you know about the Great Indian Bustard case. It's a case worth reading. This is the Indian Supreme Court, and it's all about the problems of the Great Indian Bustard. Is a relative rare, but what used to be very, very important, but become increasingly rare because it's quite big and quite vulnerable. And unfortunately, its breeding grounds tend to coincide with the areas which are most needed for solar energy and wind energy in order to implement the Indian government's commitments on climate change. And so one has there a sort of clash between these two very important issues. And an activist litigator brought this case, arguing that the steps should be taken to limit the amount of land being taken up for pylons in particular. The Great Indian Bustard has a way, it hasn't got very good sight, so it tends to bump into the overhead wires. but of course, there's a very balance. The judge was someone called Judge Chandrashukar, the Supreme Court president there, who again was someone who I've met at the conferences around the world, was a brilliant judge, but happens also to have been particularly strong on environmental issues, and in particular what he calls the environmental rule of law. And his judgment is worth reading. Again, he finds in the similar clauses of the Indian Constitution a duty to protect against climate change, but he then says that must be balanced against other environmental factors. So they set up a commission to report back to the court on how practically do that. And I understand that is actually about to report back to the Supreme Court. So there you have two judges who, viewed from our point of view, might be regarded as activists, but I think undoubtedly working very properly within the scope of their particular legal frameworks. Another arguably activist judge who's become a good friend is Judge Brian Preston, president of the highly influential New South Wales Land and Environment Court. Now, he one of the most important judicial considerations of the issues raised by climate change was his judgment in a 2019 case called the Gloucester Resources case, where the court upheld the refusal of permission for an open cast coal mine planned to produce 21 million tonnes of coal over 16 years. And the judgment is particularly valuable, not only because of the expertise of the judge, but also because he's sitting in a court with full legal and merits jurisdiction. So he's able to look at the factual evidence as well as the legal position. And it's probably the most comprehensive judicial discussion available anywhere of the technical and legal issues raised by such a project. Notable in particular is his acceptance as a relevant of the climate change impacts of consequential emissions by users of coal, which is an issue that has come up in a number of later cases. His rejection of arguments based on the relatively small contribution of that particular mine to global total emissions, and his rejection of the arguments that the coal extraction would simply take place elsewhere. Now, he's someone who undoubtedly had been active in promoting knowledge, environmental knowledge. He's combined his role as president of that court with an active role in helping to train environmental judges in other jurisdictions, particularly in Asia, without, I think, in any way putting at risk his judicial independence. In fact, I know we have some Chinese visitors here. I was saying last December, I was in China at the invitation of the People's Supreme Court with a number of other judges from different jurisdictions, had a training session for Chinese environmental judges, and Brian Preston was there as well. And I think it's probably not right to talk about activists as judges in a Chinese context, but certainly a great deal of activism, I think, has come from the Supreme People's Court with the encouragement of the government who see the problems of environment and climate change as things which have to be addressed and need to be addressed with the assistance of the courts. And they were sort of inviting a number of judges from different jurisdictions to talk about how this is done in different states. So that was, I must say, a fascinating exercise. That's something which has happened only over the last sort of 10 years. I happened to be in my previous visit to the Chinese Supreme People's Court was in 2014, when they were just beginning this new initiative. But more recently, 2 years ago, there was some guidance on climate change issues in the courts and so on. So, there's activism coming from the top in a way that, of course, we have never had here. We would imagine the Supreme Court issuing guidance to the lower courts, but that's the way they do it there. It seems to be pretty effective. So, but of course, when everyone's talking about this is one comes back to the United States, and nowhere perhaps is the possibility of judicial activism of more potential importance than there, where unfortunately the composition of the judiciary, in particular the Supreme Court, has been increasingly subject to political influence. Now, one of the most important cases internationally on climate change was decided by a 5-4 majority in 2007. That was the famous Environmental Protection Agency and Massachusetts case, where the majority held that the agency's duties to regulate air pollutants under the existing Clean Air Act included responsibilities for greenhouse gases, such as CO2 emissions from motor vehicles, and that the agency's failure to take any action was, quote, arbitrary and capricious, and therefore unlawful. They referred to global warming as the most pressing environmental challenge of our time, and they accepted the standing of the state of Massachusetts to bring the action on the basis of the threats to the coastline from rising sea levels. Now, it's interesting that the leading judgment was given by Justice Stevens, who had a conservative background and had been appointed by a Republican president, General Ford, but as has been observed, he sort of seemed to move to a rather more liberal position on many issues during his time as a judge, a long period as a judge. I mean, this judgment was given when he was about 87, I think, even older than me. But it's a very impressive judgment. But it was a 5-4 decision. The minority, led by the present Chief Justice Roberts, thought that the action should be dismissed partly for lack of standing, but also because the issues, they said, were non-justiciable. Quotes, redress of grievances of the sort of issue here is a function of Congress and the chief executive, not the federal courts. So the constitutional role of the courts, it was said, was, quote, to decide concrete cases, not to serve as a convenient forum for policy debates. Now, he thought the petitioner's victory would be, quote, little more than symbolic, but he was wrong. As it turned out, the majority judgment had profound consequences. It paved the way for the radical change of the approach of the Environmental Protection Authority, who issued under President Obama, who was elected in 2008, and who would have otherwise had great difficulty getting new legislation through Congress. But he was able to progressive policies under the existing Clean Air Act, and the EPA produced a formal endangerment finding on the Act, highlighting the severe risks of climate change, and a number of measures followed that. And that, in due course, I think, paved the way for a much more active involvement of the United States in the negotiations leading to the Paris Agreement. There are bilateral agreements with China, and we don't know what followed. And I think it's probably fair to say that without that case and what followed from it, there may never have been the basis for reaching the Paris Agreement. Now, so that sort of, under that composition of the court, there was a very strong push towards effective action. And that momentum was actually carried forward into 2016, when you had the arguably activist decision of Judge Aiken in the US District Court of Oregon in a case called Juliana in the USA, where a number of young people brought a case against the government for failing to protect them from against consequences of climate change. And her judgment was very careful, very impressive judgment, citing authorities from around the world, and holding the right to climate system capable of sustaining human life is fundamental, she said, to a free and ordered society, and thus protected by the due process clause of the Constitution and the public trust doctrine. Now, in US terms, that was probably a very innovative approach to the issue. I mean, there's nothing in the Constitution about the environment or indeed about the right to life. So was that taking judicial activism too far? Well, it was welcomed around the world as being a sort of positive way forward. But that was snapped down when the case came before the higher courts in 2019. By then, the new global consensus, of course, had suffered a rude setback with the election of President Donald Trump, followed by in summer 2017 by his announcement for withdrawal from the Paris Agreement. And indeed by a series of executive orders designed to unwind most of his predecessor's climate policy. But what I think is notable that even under that administration, when the case came to court, there was no attempt to challenge the reality of climate change or its causes in the courts. It seems that whatever the personal views of the president, his lawyers did not feel able to support those views by any substantive evidence in court. And that has continued the position. There's not been a single case anywhere around the world where anyone has actually mounted a serious case to suggest that climate change is, quote, common, as President Trump would have us believe. But when the case reached the Court of Appeals in the Ninth Circuit in 2019, although there was no serious issue on the facts, the decision of the lower court was reversed on procedural and constitutional grounds. But what it actually aims at is the strength of the statements of both majority and minority about the seriousness of the problem. Judge Hurwitz, for the majority, said the substantial evidentiary record, largely undisputed, he says, shows that the federal government has long promoted fossil fuel use, despite knowing that it can cause catastrophic climate change and that failure to change existing policy may hasten an environmental apocalypse. However, unfortunately, he felt unable to do anything about it within their constitutional role. An effective plan, he said, would require, quotes, a host of complex policy decisions entrusted for better or worse to the wisdom and discretion of the executive. The fact that other branches may have abdicated their responsibility to remediate the problem did not confer on the courts the ability to step into their shoes. So that was a very depressingly negative approach. Judge Staten, dissenting, had no such qualms, and I must say, as a dissenting judge, one knows one can probably be rather more outspoken than sometimes one can in the majority, and she puts it very strongly. She said, in these proceedings, the government accepts as fact that the United States has reached a tipping point, crying out for a concerted response, yet presses ahead towards calamity. It is as if an asteroid were barreling toward Earth, and the government decided to shut down our only defences. Seeking to quash this suit, the government bluntly insists that it has the absolute and unreviewable power to destroy the nation. My colleagues, she said, throw up their hands, concluding that this case presents nothing fit for the judiciary. But she added, no case could single-handedly prevent the catastrophic effects of climate change predicted by the government and scientists. But a federal court need not manage all of the delicate foreign relations and regulatory minutiae implicated by climate change to offer real relief. And the mere fact that this suit cannot alone of climate change does not mean that it presents no claim of very suitable for judicial resolution. It's very strong stuff that I'm surprised it hasn't been quoted more. I put in nearly every lecture I give on this health is very powerful, sadly all too true. Sadly, however, it did not prevail. An attempt was made to take the case to the Supreme Court, but that petition was rejected earlier this year. So, to conclude, it remains to be seen how the present Supreme Court will react if and when it is faced with a challenge to the policy of the President in his second term, which are even more extreme than in the first, and even more clearly lacking any rational or scientific basis. not only does he regard climate change as a quotes con, as he told the UN General Assembly recently, but he seems intent on dismantling all the measures and policies put in place to combat it, including the endangerment finding of the EPA, which followed the Massachusetts decision. So we wait in hope, but it's not for me to comment on how my brethren across the Atlantic should or will deal with these cases. But it doesn't really require any particularly radical activism, I would have thought, to hold that climate change policies, which are based unashamedly on the denial of any pretense of reality, are arbitrary and capricious, as the judge court said in the Massachusetts case, and therefore beyond the powers of any leader under any normal constitution. So I end on that positive note.
Thanks for a wonderful talk and a wonderful global tour of climate litigation, but also thank you for sharing your personal perspectives on big questions such as separation of powers and judicial activism in the context of climate litigation. I have questions. I'm sure other people also have questions. So only if no one wants to ask any questions, I will take my questions out of my back pocket. But we have about 20 minutes to discuss this. Maybe also very briefly, I'll introduce myself for those of you who haven't seen me yet. So I'm Haddo van Asselt, Professor of Climate Law at the Department of Land Economy, as well as a fellow here at Hughes. So as I said, we have about 20 minutes for Q&A. So if you have any burning questions to Lord Carnwath, feel free to raise your hand. And I'll start right here. Maybe briefly introduce yourself as well.
My name is Tanya Inolaki. I'm an independent activist. I've never actually said that in public. You're not stuttering. I have a question about whether the lecture will be available, first of all. Just that's not my real question, but will it?
We'll discuss with Lord Carnwath.
Okay. Thank you very much. I'm interested in two things. One is, maybe you've heard of the Montana decision a couple of days ago. It's a federal district decision where I think it was 22 young people from 5 different states claimed that the executive decisions of the Trump administration robbed them of their rights to a clean environment. The judge in that case said that what he would have to do to implement what they wanted was unworkable, that he would actually have to somehow monitor what a bunch of, I think something like 12 agencies were doing since those executive orders were, 3 executive orders were put through. So I'm wondering, can you talk a little bit about to what extent Indian and Pakistani precedent could be applicable in the US context in terms of setting up a commission, since this is going to be appealed, this decision? Is this something we could inform the lawyers of, that there might be precedent abroad? Is that something that happens? It's usually the other way, isn't it?
Yes.
And sorry, one more question. If you could say a little bit about to what extent UK judges are being trained on climate change at the moment. Thank you.
I mean, on the first one, Montana is a special case because it does have protection of the environment in its constitution.
This was federal.
Which is quite, yes, no, but I mean, I think they were relying on their Montana rights, weren't they, against federal, anyway, whatever that is, it doesn't matter.
Yeah.
Because the point is, I mean, it wasn't the judge said they didn't have a case, he said that the court couldn't do anything about it because it was impractical, which is effectively what the majority said in the Juliana case. For much too much sort of oversight or something. I mean, I can't see. I mean, they do have, I think, in the American courts, the idea of a continuing mandamus, where the court takes a sort of continuing supervisory role, which is not something we really have here. whereas of course the Indian and Pakistani courts are taking it much further. Now, whether that's a possibility in America, I don't really know. But I mean, it seems to me that a declaration that the court that the government is not doing enough would be very effective, because we had this. I mean, there was a case we had in the Supreme Court about air pollution or by client earth, where the point was that client earth was saying the government wasn't doing enough to implement the air quality standards required under the European law right then. And we found for the claimants, and there was a question of what we should do next. And what we did was to made an order of mandamus, ordering the government to produce a new plan. But then we gave liberty to apply to the administrative court to refer the directions. And what then happened was that Client Earth didn't like what the government used to provide its plan, and Client Earth didn't think that was good enough, so they went back to the administrative court and got a further order. In fact, they went back twice to the administrative court, and I think eventually a plan was produced which was thought to be at least workable. There's a very good article about this, I think, in the Journal of Planning and Environmental Law by someone who was actually involved in a case for Client Earth and is now working the OEP about the practical problems of putting into effect an order like that. I mean, I think it sort of worked for a lot of hard work. So, I mean, I would have thought that people don't seem to give enough force to the sheer effect of a declaration of illegality. Whether, the court can't supervise everything that's going on, but it can certainly make it pretty clear what the position is.
Thank you.
The other question was about the training of judges.
Oh, yeah.
Oh, sorry. Well, not. The trouble of it is that judges in this country are nearly all generalists. I mean, we do, all through my career, although I'm very interested about it, I've had all sorts of cases. So I don't know sort of particular environmental courses going on. I'm not involved with the judicial studies, but I imagine they do within the judicial studies board. They will have particular branches on environmental law, but not as a sort of specific thing. And we don't have a specialist environmental court in this country. So I mean, I think the effect is that the cases that come in front of the administrative court, a lot of them are about planning matters, certainly also environment, and so they're pretty well clued up. Whereas I think there's a possible risk that in some of it, in the Chancery Division, mainly dealing with sort of rather dry temporalists like finance and things, they don't have quite the same familiarity always. I'm not quite up to date with it, to be honest.
Okay, let's see.
Hi there, I'm Kaden, and I study law here and also work with the Planning Society. My question is, you've spoken to us about cases against governments primarily, and one of the cases that a couple of years ago was very interesting was Client's case against Shell, and I know you've written about it in your Grantham hat. But I'm very curious about, from a judge's perspective, how you think the matrix decision-making changes when you're considering climate issues against companies, in particular deference paid to directors versus deference paid to policymakers, whether standard or threshold shifts, or also in a factual context, how that might change for the judge as well.
I don't think it changes at all. I mean, one pays deference to policymakers who are entrusted by the law with the decision, and one pays deference to company directors who are entrusted by the company constitution with the decision. So I don't think there's a difference. I mean, you mentioned the Shell case. I don't know how many people know about that one, which is where Client Earth brought a so-called derivative action against Shell, complaining that they hadn't been, although they had a sort of net zero strategy, they weren't doing anything credible to implement it. And that came in front of a chancery judge, not a specialist environmental judge, who threw it out on the basis, as you said, that these are matters for the directors, not for the court. And I wrote an article about it, which some of you may have seen, where I said it was a sort of opportunity missed, because it seemed to me that although while accepting that the matters were ultimately for the directors, where the directors have adopted a strategy publicly of achieving net zero by 2050, they had at least some sort of duty to have some credible policies which might achieve it. But unfortunately, I don't know whether anyone will have another go at that. And I think there should be. I think the directors of companies of the big fossil fuel companies are very much or should be in the line of challenge, but that hasn't been effectively done yet.
Marcus.
Yes, thank you very much. We are hearing from the Brazilian presidency of COP30 that there is a proposal to maybe create an international climate court. Now, I thought in the international realm, we've actually in the 300 pages of the advisory opinion have heard most of what is needed to clarify the international legal situation. But do you see any function for an international climate court, a bit like the Iran Claims Tribunal or something like that?
I haven't seen a particular proposal, so I don't want to undermine anything that's done which is thought to be positive. But personally, I'm a bit sceptical about the advantages of, as you say, the ICJ has put it as strongly and clearly as one could, and a number of different international courts around the world have done the same. And really, the sort of enforcement of these things eventually comes down to national jurisdictions, which are much more effective actually because they have teeth. So I'd be surprised that there's been floating around for years as a proposal for an international environmental court of some sort, but it didn't get anywhere. And I think the trouble is that you look at the International Criminal Court, which has been having a terribly difficult time, and even I won't go into that, but I'm not terribly optimistic about that.
Any other questions? Right, well, then I'll.
Yes. Thank you for your presentation. So my name is Julian Andrade. I'm a student in the MPhil in Public Policy here at Cambridge. And I come from Colombia, where a few years ago, there was a landmark decision from the Constitutional Court, which ordered the government to halt deforestation in the Amazon. That was largely criticized in no small part because it led to a militarized response, which largely criminalized and harmed local smallholder farmer communities. And in public opinion on some human rights or environmental circles, there were criticisms against both the court and the organizations that had brought the case. Of course, a militarized response was not what the court or the plaintiffs meant, but to what extent, in general, in these types of litigation and cases, should judges or plaintiffs be held at least accountable for unintended social or political or economic impacts of the implementation of the rulings?
Yes, I mean, I know the case you mean. I know there's been criticism of it, and it's obviously, I mean, it's very far-reaching sort of judgment and orders, which tended to expect everyone to sort of run, and I'm not quite sure what sort of response was expected. I don't think one can generalize. I think all these things depend so much on the political or legal environment of the countries in which the judgments are made. And one would hope that over time, these judgments have an effect. I mean, I think the Massachusetts case is a perfect example of a case which, at the time, under the Bush administration, seemed to be not actually achieving very much, but then you get a change of administration. It's used as a tool to achieve things. I don't know enough about the Columbia situation to know how that developed, but I think I don't think people should be put off by bringing these cases because they're worried that it will have negative effects. Clearly, unfortunately, there's always going to be a balance.
In an attempt to maybe find some novel solutions to climate litigation, I was wondering if you had any opinion on the idea of giving legal personhood to environments and ecosystems such as rivers, such as in Ecuador in 2008.
Yes, I watched with interest those sort of initiatives around the world. I like the sort of Bolivian constitution, which has Madre Tierra, which has a personality. I'm not totally convinced they make much difference. I mean, someone's got to bring the case, and a body like Client Earth is very effective at doing it, and it doesn't really, and so you've got to be clear if you give personality to rivers, trees, climate, you've got to be clear what that actually means in practical terms. And I think, in some ways, I think it may be a bit of a diversion.
Yeah.
I wonder if you could comment on Liuya, which I'm mispronouncing, versus RWE, and the comments that were made, and the decision was against the farmer, but the court made some interesting comments.
This is the German case
Yeah.
about this farmer from Peru who brought an action in the German courts against RWE, the major energy producer in Germany, claiming that they're having effects on the melting of the glaciers in the Andes, which might affect his farm. I mean, I always thought that was a pretty odd case, to be honest with you. I watched with interest because I was slightly surprised that it didn't get knocked out very early on, but it carried on, even to the extent that the judges had a free trip to go and visit the site in the Andes. Well, that wasn't their motivation. But in the end, it was thrown out because not in ground of principle. I mean, that was the odd thing in a way. It was thrown out because on the facts, he hadn't proved that there was more than a minimal chance of RWE's emissions actually affecting his property. Even at the most, he was saying there was sort of less than 1% contribution. So it was a very extreme case. But they did, on the other hand, say that in principle such a case could be brought, and so one waits to see how that will work out. But I mean, in a way, it's the same with the ICJ decision. I mean, they are saying in principle such a case can be brought by a state, but it's very interesting to see how that's going to work out. I'm waiting with interest. I went to a lecture by Philippe Sands the other day where I was hoping he'd tell us all. He wasn't very forthcoming on that. I mean, the practice, no disrespect to him because he's done tremendous things, but trying to work out how in practice you have to set that information very difficult.
Thank you very much for the presentation. My name is Gaspar Lemaire. I'm a PhD candidate in political science.
Could you stand up? I don't.
Yeah. So my question is, when looking at climate litigations around the world, something quite striking is that even when litigants are successful, even when judges recognize that state conduct or corporate conduct is wrongful, there seems to be very little damage or compensation. So it seems to amount to saying, don't do it, but otherwise nothing will happen. And I recognize that there's an important expressive function of law, and this is fundamental. But so isn't there a problem here? And do you see a way to maybe go beyond that that purely symbolic approach?
No, you're quite right. I mean, I think that there are limitations, and so far there's quite a lot been said about the possibility of claims for loss and damage, but no one's yet got one off the ground. And I'll be surprised if they do in my lifetime. I think it's going to take. I mean, there's an interesting case in New Zealand you may know about where a Maori elite was brought a claim against a number of fossil fuel companies in New Zealand, claiming loss and damage due to the effects of climate change. And that went all the way up to the Supreme Court, which recently decided that the case should not be struck out, but it took them 2 years to reach that decision. And as I understand it, the case is now going back for trial for an 8-week trial in 2027, I think. And whatever that decides will undoubtedly find its way back to the Supreme Court. And if I'm still around when it does, I'll be agreeably surprised. So I think it is very difficult. I don't think there's an easy answer to that at all.
Good afternoon, I'm JX, a study lawyer as well. Thank you so much for coming to speak to us. I have a question following on from your answer to Dr. Gering's question previously. So how do you feel international courts should see their role and how should they write their judgments? Thank you. In light of the increased,
Well, I would keep them a bit shorter than some of them are. I mean, sorry, that's a slightly frivolous answer, but the ICJ judgment, which does go on and on and on, but they've got to cover all the points and cover them clearly. But I think they could, their message might be a bit clearer if they were slightly crisper sometimes. But that may be an unfair criticism. Yeah, I'm not going to offer any other advice.
My name is Ingvar Falk. I'm a justice of the Norwegian Supreme Court and took part in that constitutional case you mentioned.
Were you in that case?
Yes, I was. And I had to say, in that the issue of the competence to sit by your friend Ragnhild Lohr, our colleague, I wrote a dissenting opinion because I think, and I still think it is wrong that.
So you agree with me?
Yeah, I do. I do. But I think very much interested in what you are saying, because when you as a judge, we have some other also cases of environmental law and climate change, it's forced to consider your own role as a judge, because what kind of competence you really have and what the impact would be of your judgment at all. Because as everyone know, you can accept some emission go into the atmosphere if you do very much good things in other areas of politics. So when you have, it's not that easy to say that, well, you cannot drill that particular drill in the Barents Ocean, which was the case in Norway, if the government do very good things otherwise. And then if you accept such a consideration to be made, the cases will be very, very broad. You cover all aspects of a particular case will cover all aspects. And the rationale behind that Norwegian judgment was that, well, this is for the legislative and governmental bodies. It's part of the separation of power. That it ended up, but the case is now in Strasbourg, so we will see. But and we had other cases going on, more on other aspects than the constitution.
No, I mean, well, I'm sorry, I didn't realise that you were here, but I'm glad we agreed on one thing anyway. I suspect if the case had come in front of us in our court here, we'd have probably taken the same sort of line. But so we don't have a sort of clear constitutional protection. I mean, I thought that was quite interesting about the way that it's actually expressed in quite strong terms. But at that stage, I mean, a pure exploration, I can see why they took the view you did. And I mean, I haven't talked about the Strasbourg case, the Swiss women's case, but that was undoubtedly, or at least many would regard that as a very unduly activist approach by that court of finding a sort of right to the protection from climate change in the European Convention, which there's nothing at all about it, not even about the environment. I know my former colleague Jonathan Sumption gets very cross about that. I don't get. I mean, it doesn't worry me because I mean they're just simply saying what in fact the international court is saying as well. So I don't, even if they're going beyond the wording of the convention, they're not doing anything particularly drastic. But I can see that, yes, how we would have dealt with it, and we may start, I think with the North Sea exploration, we're sort of coming up to crunch decisions on that, which I'm sure are going to be challenged if they go. So we'll see. So I don't think there's an easy answer. And as you know, sitting in a court, one has all these different considerations. One guides always be within the sort of particular legal framework that one's trying to decide with it. So I hope we all manage to keep that objectivity.
Final question, and then we'll have to break it.
My name is Habib. I'm from South Asian country, Bangladesh. I'm doing a BTC basic training course in BPP, University of London. So my question is that how can judges and lawyers in countries like South Asian countries like Bangladesh, they use the international environmental law because most of the international environmental law are making like European countries or American countries. So Asian countries like Bangladesh are mostly affected by climate change issues, but very slightly we are making laws. So how can our judges and lawyers can use to protect the community, protect the affected people? Thank you.
Well, I think I've met some of your judges. I've been to conferences in Bangladesh where, and I think like in the other Asian countries, they've been quite progressive and arguably. Do you think they should be more progressive than people? One of the troubles you can only do so. I certainly believe the judge's primary role is to interpret the laws which are made by Parliament, not to sort of invent things. And there's only a limited range within which one can sort of try and help. I think a lot. What I find is actually one has the remedies are quite an important part. The fact that once you made your decision, actually making sure it has effect, which is what we tried to do in the air pollution case, because I think there you have more flexibility. But I don't think I can. I haven't met all your judges, but the ones I've met seem to be very much on the ball.
Right, so we'll have to stop now. We're 5 minutes over time already, and so there will be some drinks and snacks outside the room for those of you who want to have a chat. Lord Carnwath will need to leave in about 10-15 minutes, but he will be there for at least a little bit for you to have a quick chat with him. But let me first start by thanking Lord Carnwath for a wonderful talk and for a wonderful Q&A. So now I'll have your attention. There was one question that came up, which is, what about compensation? How should we deal with that? And my response to that would be, come back in 2 weeks, or come to the date after in 2 weeks, when we'll have Harsh Narula from Dutch Street Chambers talking about exactly that, about reparations and climate change. To what extent can we provide compensation? Can we provide reparations? So that will be the next one in this seminar series. But there will also be others on company law, on contract law and climate change. So you're very much welcome to join us also. And you can sign up for those talks online and through the links provided, or you can look at the sheets here. But again, thanks for coming. Thanks particularly to Lord Carnwath for a wonderful talk. And we look forward to continuing this conversation over a drink right now. Thanks.